Donc, on va continuer avec...
We're going to continue in the wake of the last session, because session 11 wants to examine the possibility offered by the tools that we have in copyright, and see whether we can use this data to get some quality statistics. So our moderator is an expert because he works at the World Intellectual Property Organization. He's head of intellectual property statistics at the World Intellectual Property Organization based in Geneva. As such, he's responsible for the collection and dissemination of World Intellectual Property Organization, intellectual property statistics, and also actively involved in the development of methodologies and new intellectual property-related indicators. Before joining WIPO, he was an economist and statistician at the Directorate of Science, Technology and Industry at the OECD, where he mainly focused on the collection and analysis of S&T indicators, so indicators in science and technology. He also worked for Eurostat and also for consulting companies and academic institutions. His research work has been published in academic journals and books. He holds a master's degree in economics from the University of London. So you have the floor.
Good afternoon, everyone.
Bonjour à tous et à toutes.
First of all, I think I would like to thank the organizer for giving me the opportunity to represent WIPO, the World Intellectual Property Organization, to chair the session. It is a great pleasure to be here, and I think we have a very good agenda for this session on IP, intellectual property in digital era. Now, on the agenda, we have 3 speakers. Unfortunately, one of the speakers could not be here, so we'll end up with 2 speakers. Next to me, we have Madame Françoise Benhamou, who's going to give us a presentation on copyrights area. And we also have another presentation from Caroline, who's going to be on the sort of video conference. So before I go into invite the speakers to give you an overview of IP in the digital area, what I want to do is set the theme, set the sort of broad agenda for this session, and hopefully, based on that and based on the presentation, that we can have a fruitful discussion. As I was introduced, my name is Mosahid Khan, and I'm head of IP statistics at WIPO. Probably most of you, some of you know WIPO, but in case you're not familiar with WIPO, WIPO is World Intellectual Property Organization that deals with intellectual property rights at global level, international level. It is one of the UN specialized agency, one of the specialized agency with the mandate to deal with the IP issues at international level. So we deal with areas such as patents, trademark, industrial design, copyrights, utility models, traditional knowledge, number of issues. We deal with that. But here, what I'm going to focus on is the copyright area. And this is what our presenter is going to present their paper relating to the copyrights. Copyrights is a very important aspect when it comes to talking about the creative industry or cultural industry. Copyrights is essential for this area, and the reason for that is copyright provides a mechanism where creators, innovators, they can have control over their creation. So copyright provides a market mechanism for creators to benefit from their fruit of labor, if you want to call it, or their investment or hard work. So copyright has a big role in creative industry. Think of it, if you didn't have the copyright rules and regulation, and there wasn't a possibility for creators and innovators to benefit from their hard work, in the long run, we might not have a sustainable creative and copyright industries. So this is one of the things which I want to first outline about the importance of copyrights in this area. As we are here for talking about statistics, let me just throw 1 or 2 numbers. Recently, there was a report done by Ernst & Young. It is a consultancy company on behalf of CSAC, one of the CMOs, which is a collective management organization. And in that report, what they found is at global level, in terms of revenue, copyright generated 2.2 trillion US dollars in 2013. That is equivalent of 3% of the world GDP. That gives you some kind of indication of the magnitude of the sector. In terms of employment, according to this report, 29 million people are engaged in the copyright-related industries. So that gives you sort of magnitude about the level of involvement of the general public. So we have to keep this in mind. There are other numbers that are available, but I just picked one example to generate some discussions about the importance of culture, copyright, and creative industries. At WIPO, we deal with the issue of copyrights. There is a committee which is called Standing Committee on Copyrights and Related Rights that was set up in 1998-99, which deals with the international framework on matters relating to substantive law and harmonization in the field of copyrights and related rights. So there's a lot of activities going on at WIPO in terms of normative setting, developing rules and regulation. I am responsible for statistics, and we have a great deal of data available for other IP rights, such as patent, trademark, and industrial design. When it comes to copyrights, there's a big black box. We don't have much data. And I want to pick that theme later on. As one of the objectives of this symposium is to discuss about the data collection that is internationally comparable, that is easily accessible to public. Now, I'm going to stop here. What I want to do is first hear from the speakers, and then I want to open the floors and get you as participants to engage in this discussion about the importance of IP in the copyright-related industries or culture and copyright-related industry. Now, the first speaker we have is, we're going to take, she's going to join us by the video conference. And the speaker we have is Caroline Nwabueze, who is from Enugu State University, Nigeria. Do we have this working? Okay, well, this is working. Let me just give her a background about Caroline Nwabueze. She holds a Master's of Law from University of Torino, Italy. She also has a Master in International Law from Handong International Law School in South Korea, and PhD in Law from Dula University in Cameroon. She is a lecturer at Enugu State University of Science and Technology in Nigeria, specializing in the field of law and development, advocating for use of international legal framework as tools to enhance the capacity development of unnoticed communities. Her concern for development has led to her conduct research in the field of traditional knowledge and cultural heritage community in the developing world. She has led several research projects on intellectual property as a tool to sustain development potential of local communities. She has served successfully at Traditional Knowledge Department at WIPO, at UNESCO, and at the Central African University. She is currently a candidate to a degree of Doctor in Law at the University of Bern in Switzerland, where she is conducting research on intellectual property and documentation of indigenous knowledge. So Caroline, the floor is yours, if we can get you online.
Hi, thank you. I don't know if you can hear me well.
We can hear you, I think, from this room we can hear you, yes. So
thank you.
Basically, you have 15 minutes, and if you can focus on your presentation and try to stick to the time limit, and give us the main theme of your presentation and some of the issues that are important that the audience can discuss about these issues.
Thanks a lot. I'm standing on the existing protocol to deliver my paper for the International Symposium on Digital Product. And the title of my paper is Sustaining the Authenticity of Heritage Data in a Digital World. And I'm calling for an intellectual property governance model. As previously underlined, the issue of data collections in the field of heritage raised a lot of intellectual property issues. But the present paper intervenes against the background of the 2005 UNESCO Convention on the Protection and Promotion of the Diversity of Cultural Expression. The Convention does recognize in Article 5 as part of member states' obligations the need to promote fruitful diversity of cultures for the respect of cultural rights as well as formulation of cultural policies which promote cultural diversity. Culture, as addressed in the present papers, refers to intangible cultural heritage, such as under in Article 2, Sub 1 of the 2003 UNESCO Convention for the Safeguarding of Intangible Cultural Heritage, including practices, representation, expressions, knowledge, skills as well. So we can see from the PowerPoint displayed on the screen several images of what represent intangible cultural heritage. Intangible cultural heritage represents cultural creativity in a rich way, and it is really the heartbeat of cultural diversity. Therefore, it is important for intangible cultural heritage to receive proper acknowledgement in the course of safeguarding when, for example, cultural industries are involved in the process of data collections. Digital methods have been used for the past decade as tools for the safeguarding of intangible cultural heritage. And we can see, for example, that in the field of documentation, we can see, for example, in the field of digital collections, how digital methods have been used to create, produce, disseminate heritage data. Digital methods allow to handle greater amount of multimedia content at low cost. But there is a problem. There is a problem with the institute in charge of those data collection, because digital creators create their own information environment. Digital creativity enables to reimagine cultures, share files, and otherwise contribute to the explosion of content available online, authentic or not. It increases misrepresentation of cultural creativity, diversity. And that constitutes a trait for the authenticity of data displayed by cultural industries, centers such as the World Intellectual Property Organization or Institut de la Statistique in Montreal, or other centers like UNESCO in Korea, because they rely on the use of those online archives to produce their statistics, and also they rely on digital museum collections, equally rely on cultural center electronic repository. And they enable dissemination of content beyond the reach of communities' knowledge holders. By ignorance of the existence of such database online, and also because of the remote location of those knowledge holders, they cannot stand as advocates concerning the authenticity of those data used by Cultural Heritage Center. We have the case of the Aborigines in Australia. We have the case of Indian communities, owner, for example, of the turmeric plant. In the turmeric case, we have, for example, the case of South African indigenous owner of the Salacia plant involved in a fake patent application in April 2010 at the PCT, World Intellectual Property Organization. And that is what Article 5 of the Convention on the Promotion of the Diversity of Cultural Expression does requires in Article 5 that intellectual property is important. Number one, state should adopt measures to provide state to adopt measures to provide the safeguarding of cultural expression. They should adapt measures to enable the cultural diversity to be respected. And also the preamble, of the Convention of the Promotion of Diversity of Cultural Expression, those mention the importance of IP rights in sustaining those involved in cultural creativity. And that's why I want to join the former speaker talking about the role of copyrights in sustaining data collections in the field when we talk of 5 findings in the field of heritage. Article 6b of the Berne Convention does mention that the author can claim authorship against distortion, mutilations, modification, or other derogatory action against his work. The right to integrity and the right to authorship under moral rights in copyright do allow the copyright owner to fight a lawsuit in case of abuse related to his image, his authorship, the misrepresentation of the cultural content related to heritage data. So, when we talk of IP right category that will sustain heritage digitization, we have Article 6b of the Berne Conventions that will enhance protection of the integrity of the work and prevent it from being distorted and mutilated. So therefore, when the work will be disseminated, and when a cultural center will have access to the work, there will be insurance that the authentic aspect of the work has been respected. Also 2 years ago, the copyright section of the World Intellectual Property promoted the use of registries and documentations as tools to enhance the authenticity of the data in the field of culture. And this also goes in the same sense with Article 11 of the UNESCO Convention on the Safeguarding of Intangible Cultural Heritage. The convention says that the communities which are actually the owner of the cultural heritage should be associated with the management of their cultural heritage. We have a sustainable case, is the case of the Indian digital database that has been used as evidence of prior acts in the field of traditional knowledge. And we have the turmeric case where an element of the Indian cultural heritage was actually misappropriated, and the person who misappropriated the plant wanted to apply for a patent protection in another state. But because there was a prior documentation of the Indian traditional plant medicine, there was evidence of prior existing knowledge, and therefore the patent application was cancelled. So registries and documentations can come along with moral rights under copyrights underlined in Article 6b of the Berne Convention to enhance protection of the traditional knowledge rights over their cultural heritage, and therefore enhance authenticity of the data used by cultural center. And also in the field of industrial property rights, we see the case of patent, trademarks, and design rights that will enhance to acknowledge the ownership of communities over their cultural heritage when it comes to data collection and dissemination of statistics. And also we have the Nagoya Protocol, which does recommend the prior informed consent of communities holding traditional knowledge before any data collection. So it is important for those measures in the field of copyright, in the field of industrial design, to be associated, to be used in, by cultural center in charge of data collection before displaying statistics on heritage data. Why? Because if they only rely on what is displayed by the internet, we don't have the insurance that those data on the internet are authentic or not. But if the center takes the prior measures, undertake the prior measures to ensure that there has been maybe a kind of protocol, a kind of agreement with the community, and they will see maybe as part of the website, the document related to the website managing those heritage collection, that such agreement has been signed before the collection of the data. Those data could be said to be authentic. But in the absence of such protocol or such document or registry located in the communities, it will be difficult to ensure about the authenticity. And if those measures are not implemented in the coming 20 or 50 years, the world will be struggling with unauthentic heritage data in the digital world, because the cultural institute involved in data collection and in charge of statistics cannot ensure the authenticity of such data because they are foreigner. They do not know the origin of those data.
Caroline, I don't know whether you can hear us.
Yes.
What I want to give you is 2 minutes to wrap up your presentation. We'll come back to you later on during the discussion when you open the floor to audience. At the moment, if you can wrap it up within 2 minutes, just highlighting the key issues, and then we'll open it for the discussion later on. Thank you.
Okay, thank you. To round up my presentation, I would like to mention that it is important because we have an issue of authenticity of data in the digital world concerning cultural heritage. It is important, number one, in case of data collection, to ensure authenticity, and copyright does stand as a sustainable tool to enhance authenticity. Number two, it could be the existence of documentaries in the community standing as evidence of traditional knowledge or heritage data in the community. And also, there could be kind of protocol, covenants, where the community will sign and ensure the authenticity of those data. So copyright comes as a tool to sustain authenticity. Intellectual property rights, also such as trademark and design, can serve as tool for the authentication of heritage data. And I would like to close with this word from the World Intellectual Property Day concerning digital creativity and reimagination of culture and the risk arising for cultural institute in charge of data collection. It was said during the Intellectual Property Day in Geneva 2 weeks ago that only a balanced and flexible intellectual property system can help ensure that those working in the creative sector and artists themselves are properly paid for their work so they can keep creating. And I will just conclude by saying that intellectual property is also a tool to ensure authenticity of the data collected by the Cultural Institute. Thanks a lot.
Caroline. Caroline, thanks a lot. First of all, thank you for sticking to the time. You're exactly on time of 15 minutes. That's great. I hope you'll stay with us and follow the discussion online. What I wanted just to reinforce what you just said and keep it for discussion, 2 issues you raised. One is the authenticity of data. How do we make sure that data are authentic? What is in the database? And the second issue you raised about, and I think it's very important, is documentation of existing knowledge and cultures. that is very important, and I hope we can touch upon that later on. Let me move on to the next speakers rather quickly so we can have the presentation and follow the discussion. So I have next to me Madame Françoise Benhamou, who is from Autorité de régulation des communications électroniques et des postes from France. I think most of you are probably aware of the work Françoise has done on, in terms of culture and digital economics. She is an economist and university professor specializing in this area. She sits on board of the ARCP and a number of associations. I just want to mention one or two. I think that's quite impressive and brings in different dimension to the discussion. She sits on the board of Louvre Museum and the National Heritage Institution. She is also a member of the advisory committee of RTE programs and was previously chair of the Association for Cultural Economics International. She has authored a number of articles and books about cultural economics. So I think we have a very excellent speaker who has a diverse set of experience in this area, and we look forward to hearing from him.
Thank you.
The floor is yours.
I can take
Yeah, sure.
Thank you. Bien, merci pour cette invitation.
So welcome for this invitation, and thank you for the audience to attend despite the wonderful weather outside and of the debate. Actually, I will echo many presentations that we've heard throughout the 3 days. The issue I would like to ask is upstream technology collection, which is quite complex. We already know the galaxy of author societies, which are usually monopoly in their fields. They are related to their own territory. But I would like rather to focus on the digital goods as products. Indeed, we shifted from an economy of goods towards a service economy. And in an economy of services, most of its transitions do go through the economy of copyrights. And actually, it's quite striking to consider the huge precarity of many authors. We talked about the star systems and the long tail of those who are very successful whenever the success ends up in the artist's hands. But the field is much more challenging nowadays. In France, there was a survey showing the precarity of authors nowadays. We have the same challenges in the field of photography, where many photographs takers are disappearing because of the digital photographs, but it's also the same in the field of music. And actually, it's paradoxical because it goes together with the multiplication usage. We've never read so much, not only books, but also blogs, etc. We've heard a lot. We hear a lot of music. However, authors are having a hard time in living from their works. And if it is so, it's because maybe it is very hard to monetize or to give a value to those usages, to these uses. So to give you an overview, a few points. I wanted to start with an introduction. The intellectual property is more than ever necessary in the digital era. Why? Because the cultural goods in this digital world is becoming an intangible asset that everyone can buy or get, whatever the cost, or without any cost. And this is actually why it will benefit to the property monopoly. But at the same time, intellectual property is more than ever fragilized. I've seen so earlier on. It's not only through piracy. It has a lot of costs, even though economists do not agree upon them. But those are costs. It's a lack of income, but it also requires costs to struggle again or to address the issue of piracy. those people are very inventive and the regulators are not so creative. So we have to find new ways of addressing these technological issues. So this creates tensions around intellectual property. How can we strengthen it and protect it? So we have tensions, very strong tensions in Europe, through debates that were initiated through a report from Julia Reda very recently. And indeed, it was quite a provocation because Julia Reda is a Green MP, but before she was a piracy MP. She belonged to the piracy party. So it was quite surprising to have her draft such a report, but it's a very interesting one. There is also the idea of the digital market. It's a digital market not only for networks, but also a single market that should be single only for or unique for the copyrights area, where we have national issues coming from the history in the European market. So just one example, the debate on the pedagogic exception or education exception, which was actually addressed by publishers who said that it was the source of the cancellation of the annihilation of the whole pedagogical market. So to address this, I choose 5 main discussions: the length and evolution of contracts. The second issue would be the nature and the magnitude of exceptions. The third one deals upon open access. The fourth, geo-blocking. And the fifth one, streaming. I will be very brief on with each one. Actually, I was unable to. I had to quote actually the Le Chapelier legislation dating back from 1791. Maybe weird to speak about such an old law in the digital era, but actually already during the French Revolution, when we debated about copyright, we debated already about the length. Whenever we mention Le Chapelier, where it states that it's the most sacred, the most unsaleable, and the most personal of all properties. But in such legislation, they mention that at some point public rights to property have to come into effect, and everyone must be allowed to print and publish the works which have contributed to illuminating the human mind. As you see, this kind of debate already existed back in the Enlightenment area between Condorcet and others. But what does it mean nowadays? It means that whenever we talk about public domain, we have 3 different issues. What's the territory of the public domain? What's the nature of said public domain? Do we have to define a very wide field or a smaller one? And how do we process this public domain? Do we have to create a paying public domain? It was actually a proposal from Victor Hugo, going back to the past. All those different issues are dealt with when we talk about copyrights. As I mentioned, authors are in a very precarious situation because as long as their works are being digitalized, they would like to have a more interesting pay. They want the remuneration basis, including all the values of the works, including through advertisement. They will ask for the cession of their rights to the producers should not be too long, that it will be not left with the copyrights length, so 70 years actually, or the eternity. So authors will ask for the contracts to be discussed again because this digital market is not very well understood. It has to evolve, and the best way would be to have shifting contracts adapted to the evolution of the market. Actually, there was such a negotiation in France on those issues which are core to the debate. The second major field I wanted to delve into is the nature and the breadth of exceptions. As you all know, international law does not actually define any minimal basis in terms of exceptions. We just have to go through a test in 3 steps, and so it has to be limited to specific cases only. It doesn't have to violate the normal exploitation of the work, and it shall not cause any prejudice, unjustified prejudice to the legitimate interests of the right holder. Obviously, we have many controversies. It's been debated in Europe, but also elsewhere. That's the panorama right, or the liberty of panorama. In other words, one of the possibilities, it's right, involved with different public work arts that we would like to take a picture of. And the question is whether we can take a picture freely. Yes. Can we sell our pictures of public works? No. It seems to be easy, but as long as you are in the digital world, everything becomes complex. For instance, Wikipedia is asking that the commercial exploitation be possible. We wonder, Wikipedia is quite a non-profit organization, so how come? Well, photo pictures on Wikipedia will be copied and forwarded to personal Facebook accounts, for instance, and maybe there might be advertisement made of these pictures, and no, we turn to the trade industry. So that's why there is a challenge here related to the copyright, so that the cursor between the non-profit and the for-profit and the commercial and non-commercial. That was quite easy to deal with in the past, but it's harder to position this cursor. Another controversy, or it's the open access. You've heard about this in the globalization of research, and we have researchers who are competing, but they want to also work together, collaborate. We have major issues with international libraries who have fees to pay to the academic journal publishers. So it's an open access to research which are being granted. So there is an increasing debate being developed as to, yes, indeed, open access is fine, but there is a challenge for the publishers because they have to pay, and then they have to put their articles on the open access. So those are, again, the different issues as I was mentioning earlier on. I'll try to go faster. So we will have the same debate with the issue of rights valorization, and especially in the streaming field, which helps fighting against the piracy. It's a new way of consuming. But then, on the other hand, you have millions of people using the streaming. But at the same time, we know that the economic models are no longer there, so authors are not well paid through the streaming. But on the other hand, we don't have the major streaming models either. So what is paying comes from the subscribers, but then the consumers do not subscribe. I just went over a point, that's the geo-blocking. Here again, it's a bothering topic, but when you subscribe to the on-demand video platform and you cross the border, at some point everything is blocked because the rights are depend on the territory. That's the condition of economic models in today's audiovisual, and at the same time, it's something that the consumer does not understand. He will say, well, I go across the border, who cares? I still want to be able to benefit from my subscription. The risk here is that should the rights become globalized, or is the increase of the fees or of the price. As a conclusion, many different paradoxes. As we can see, we are in a moment when we really need the copyrights, but at the same time, the copyright has to evolve with some reflex or reactions that are rather very defensive ones on behalf of the authors' societies, from some producers, companies, etc. Why? Well, because economic models are not there. We are really at the beginning of those new economic models. So in order for the rights to be moved upstream, the whole model has to be sustainable. We haven't yet found the appropriate model. Everyone is working on this, so label, etc. But also many more solutions may come from the new incomers in the different branches or sectors of the industry. And there is a major challenge. So goods and services in the digital industry or era are becoming manifold. Yesterday we were mentioning that e-books yesterday are only in content when they are enriched. They are no longer e-books. So the issue of upstreaming the rights, how do you do that, and what are the costs related to the transactions related to the work of author societies are becoming more and more complex. So thank you very much for your attention.
Thank you very much. Thank you for
Merci beaucoup pour avoir respecté l'horaire. Avant que vous ouvriez la parole pour les questions, je voulais peut-être approfondir certaines questions que vous avez ébauchées quand vous parlez des libertés d'auteur, des questions.
I hope we can explore this area that authors or creators are having a hard time to make a living. On one hand, we hear a huge amount of money being made. On the other hand, we hear from creators that there's not enough money filtering down the line for them to make a decent living. So that is a very important issue. Next issue, what you mentioned about, and this is related to that, is piracy or illegal downloading and streaming. And that has an impact on creators and flow of money to the creators. When you talk about the copyrights or any form of IP rights, we look at the IP rights by nature is territorial. What has happened with the technology, the boundary has disappeared. And that is one of the issues that technology has pushed us to a direction that IP policy is not in line with that. So how to deal with this and finding the right balance is one of the critical issues. In terms of technology, digital technology and internet, I see two sides to the story. One is it has created a lot of opportunity. If you think about the creators, whether a small-time filmmaker or a musician, the technology allows the creator to reach out to the whole world. It makes it possible that he can make a video and make it accessible to everyone in the world. At the same time, it has created challenges, and the challenges are what you mentioned. How do you keep control to commercialize and exploit your creation? How do you make sure the revenue, you benefit from the revenue generated by your creation? So that is the challenge. And I think IP can play an important role in this area. But the positive side too is that, look, one is that reaching the global world, but also it has reduced the cost. As a consumer, you benefit from that because the cost of production has decreased. When you create something and you want to duplicate that, the marginal cost is close to zero. So you can duplicate, put it out in the public domain. So consumption-wise is pretty good. But the challenges one is how do you make sure that it can prevent illegal downloading, illegal streaming, and the access to your revenue. So those are the flip side of the same coin. But those are the two issues I think is fundamental in terms of when it talks about the IP rights and that in the digital area. Now, I have a number of other issues which goes back to the database. as I mentioned earlier, that I'm responsible for IP statistics at WIPO, and we have very good data collection when it comes to patent, trademark, industrial designs, and other forms of IP rights. When it comes to copyright, it is extremely hard to get good data. And the reason for that is the nature is different. With other form of IP rights, you have public institution where you can get the data from. So for the patent, every single country has a patent office. Information is recorded, and we have access to that. When it comes to copyrights, we have more data than other forms of IP rights. But the problem is, or the issue is, we don't have access to the data. And the reason for that is the stakeholders are not the same with other IP rights. People who are holding the data are private companies. I think throughout the conference, we have heard a number of speakers mention the name of Netflix, Amazon, Google, Facebook. They have really detailed data. They can monitor everything in terms of when it comes to consumption of the product, what sort of product being consumed, from which location, how often. But the data is in the private domain. So the issue is, and what was mentioned, I think, at the beginning in the opening session, is that establishing cooperation between public and private sector. That is a big challenge, but we're faced with that, and we have to deal with it. In terms of course, public companies, they have their vested interest. A lot of the business, especially in the tech world, depends on data, and the data generates income. Their business model is based on data. It's data-driven. So of course, it's not in their interest to disclose this information to the competitors or to the general public. But we've got to find a way to convince them that if they share the data, they will benefit from the data. So I think I'm going to stop here. I have a few more other points, but what I want to do is I just want to hear the reaction, and I want to be interactive and get the reaction from public before I ask you to comment on further. And I hope Carolyn is still with us online, and she can contribute to this. So what I would do is I would invite the audience, if you have any questions that has been raised during my intervention, during two speakers, if you have any issues that you want to raise, whether it's a comment or whether it's a question, please feel free to do so. But first thing what I would like to do is please if you can introduce yourself and the organization you belong to, that would be helpful.
Bonjour, mon nom est Guillaume.
Hello, I'm Guillaume Dizienne. I am the president of the I don't remember what, je ne sais trop quoi. My question is for Françoise Benhamou, should we consider pirating as a stakeholder or something that we should measure as a success? Let me think about it before answering. I would just say a word about collection. There are two things in collection. For example, in France, it's very, very, very clear. You have the collective management, and then we have data that is quite reliable. And then you have other part, which is direct management, like, for example, a publisher who's going to pay an author. And these are data that on which we have to rely on statements from publishers, and there we have more unreliability on data. Now, pirating, it's a very difficult question to deal with. First of all, it is not very well known by definition. There are two biases when you're evaluating pirating. We don't know what is the nature and the intensity of a pirating, and very often we ask people, and for example, there was some studies that were done in France by Motif in the Paris area. We are asking younger people, are you pirating? We will not denounce you, of course, but are you pirating? And they say yes, no. So we don't know the intensity of pirating, and we don't know the opportunity loss. It's very difficult to calculate because anyway, there was one part of pirating that would not have been bought by those who are pirating. So we have a double lack of knowledge of this phenomenon. The fact that it is a loss, it's obvious, and that we have to learn to live with it, well, it's obvious, and we don't know it well, it's obvious too. So we have to learn with a parroting that be compatible with models of economic development. For example, the parroting did not wait for the age of technology. For example, when you're making Xerox copies, we did that at the university, well, this was also a form of pirating. This brings us back to what we have been talking for the 3 past days. There was a company called Big Champagne that used to listen to torrent and be able to measure, to assess the success of certain files that were transmitted from one person to another person. Metromusic.com offered access to this type of data. Certain actors in this area were able to measure the success of some music or some proliferation of music through pirating. If you take away some letters from piratage, it becomes partage, and so we could see that certain artists unexpectedly were making more money in Brazil than in France, and so it is possible to measure this pirating without having to go on to organize focus groups. And also, it is no longer an issue because very soon nobody will pirate files because we're going to have access to those files through streaming. So, in the very long term, of course, there are other countries where downloading of MP3 is done more than here. But if the current trend confirms, well, very soon we'll not do some downloading and we will listen in streaming. And so this is just to tell you that there are ways of measuring pirating. Well, yes, certainly in music. Hello, Evelyne Pavretti of the Association Nationale des Éditeurs de Livres, so the National Association of National Editors, for the Canadian Code of Copyright. So here, context, there has been a modification on copyright law in 2012 that includes 40 exceptions. And, for example, the school exception that is affecting us in publishing and the school editors that we represent in the association. According to the law, after 5 years, there is a review of the law, of the federal law on copyright. So it will take place in November 2017. So we are trying to see how to compile our dossier, given that in 2012 there were a strong motivation to denounce those exceptions. Now the problem we are confronted with, it has to do with statistics. This is to say, how to quantify the impact of the modification of the 2012 law in Canada. We have personal impressions, for example, some feedback from the field saying that there's some impact internally, and also some international feedback from the EPA that sent some letters to our ministers to denounce the situation. With the last decision of the Commission of Copyright that was made in February, last February, but we have some feedback. But when we're facing ministers, we do not have anything solid. We don't have any solid data to quantify this impact, to give some firepower to the feedback that we have been receiving from our members. And so my question is the following. Because with my school editors, we ask ourselves a question: how can we measure this impact so that we can then, in 2017, have a solid dossier on the impacts of school exceptions? It is clear that by definition, that those exceptions reduce the possibility of the channeling of fees. So that's the definition. So it is not to counter this idea so we can measure this. But I think that when we have so many exceptions, this impact can be balanced by an evolution of the way we are doing school edition. I can give you an example here. There are huge possibilities that have been open with other forms of privilege, with enriched books. And so there's a possibility of opening new markets where and you will not be able to counter this this exception that is a product of the evolution of customs and of collective will of people. But a way of answering this is to try to open other markets that will allow you to get some revenue by efforts of the auditors that were done. This is where you have to work, because otherwise the impact, well, other books that were sold and that can be reproduced. This is where the opportunity loss is. But if you can be creative in editing, well, you can still have something to play for. Hello, Atelier Charbonnier. I am I'm a university candidate, and I'm doing a PhD on public law, and I'm countering my colleague here, who is very, very depressed when there are exceptions. But I'm very happy about it because wait! I'm not done yet. I am very happy that the Canadian legislature has finally recognized in 2012 the right of legislating on the public domain, because it is making available to the public things that were covered by copyright. And what is very, very interesting in this introduction, and we have 20 years late in doing this, is that this corresponds to what you're saying. Looking for new markets, perhaps the emerging paradigm. This perhaps one message that I could convey to our to the editors in Quebec. There's perhaps a new way of exploiting the new market in Quebec that goes through digital. So instead of selling books on paper, perhaps we can think of a digital access that could be negotiated through, for example, a company of management that could make those work accessible and could be disseminated to all school commissions in Quebec. But this is my comment.
I wanted to touch upon Mr. Khan's comment about the accessibility of data for copyrighted works. And one of the ironies of the Berne Convention of the 19th century is that there are no formalities for requiring the emergence of copyright. And despite the American experience for many decades, the Americans moved into the international family with regards to that. But what is interesting to note is that more and more collecting societies are actually a source of data that is private, but still in perhaps a hybrid mode, not quite fully in private commercial hands, but in these kinds of, especially in Quebec and in Canada, these are usually either nonprofit organizations or controlled by a community of interests. And so maybe there's a way to think about how the data from collecting societies could be pulled together in order to attain that knowledge about the industry. Thank you.
Let me just give you, we don't have much time, but if I can take 1 minute, let me just address this. This is quite an interesting idea you have mentioned. Yes, CMOs, collective management organization, they're not private, they're more of NGO type or semi-public. And most of them, I've come across that they do publish annual report where they make available aggregate data. Now the issue here is we have to build trust with them, and trust is very important. Before they share any information, they have to trust you. What we want to go is go beyond the data which is available at aggregate level, detailed information, then we can monitor the flow of the revenue generated and the distribution of revenue through the chain. That is very difficult to convince people to share the information on, but I think this is the right way to go about. And I think we'll have better luck with NGOs or semi-public institutions than with private entities. I think I want to stop here as we have run out of time.
Well, thank you very much. Thank you. On va s'arrêter pour la dernière pause.
We will break for the last time before we move on to our 12th session. For our 12th session, we will look at the impacts of digitization on the remuneration models for creators. We will reconvene at 2:55. Thank you.